Hello folks, welcome to the Edupedia world, and I am Abhinay Gupta. Today again we'll continue with the topic, the appointment and qualification of directors. Right? Pay great detail of attention because this is one of the most important chapters. So, in a previous lecture, just the preceding lecture, we have understood the various disqualifications attracted to a director on his personal capacity and also the disqualifications attracted due to the default of a company, right? Covered under section 164 subsection 1 and 164 subsection 2 respectively. So before we go ahead into details of some other topic, like today we'll learn about the appointment, we'll learn about the DIN, the procedural part of DIN, right? We'll cover the sections of Companies Act 2013 that are related to the application, allotment and the other procedures for the director identification number. But before that, since the topic of qualification and disqualification of director was a very important topic from your exam point of view, we would like to discuss some of the recent past year questions that have been asked for that particular topic. So before starting the chapter, we'll discuss some of the topics, right? Some of the questions that have been asked in your past examinations based on the disqualification of directors. So the question on this topic has been asked a lot number of times in your CA final examinations in the past, right? So starting with the year 2002 till the latest year 2013. So in the year 2002, you were asked questions from section 164 subsection 2 where the company had failed to repay the matured deposits, right? So the basic crux of this question was that the deposit that we're talking about, so in the examination the question had given you a case where the company had failed to repay the matured deposit, right? And then you were asked as to what is the company supposed to do. So first what you do is you write down the provisions of the section 164(2) that attracts disqualification for the director for 5 years, right? And disqualification means no reappointment, no appointment and everything. And then there are a few other things to write, right? As per the question, you will say that yeah, if he is unable to pay if it defaulted in the payment of matured deposit for a period of more than 1 year, right? In the case, yeah, it was more than 1 year, so the director would be disqualified, right? And so he has to vacate his office after that. But again in the question, as per the case, if the director resigned just before the company attracted the default, the director will escape the disqualification, right? And also that the auditor of the company shall state in his report as to whether or not any director of the company are disqualified for being appointed. So these are the basic requirements of the question, and this was although discussed in the topic when we were discussing it in the previous lecture. I wanted you to keep these points intact in your mind, right? That if you have to default in payment of public deposit, number one, there has to be, the default has to continue for 1 year, and if you resign before that default attracts to the company, you escape, and the auditor will have to report about the same in the auditor's report too, right? Next, you were again asked the question on this topic in CA Final May 2004. And in that time, you were asked from section 164(1), right? And few of the disqualifications individually attracted to the director was straightforward asked in the question. So you will have to just jot down the provisions that as per the section 164(1), these are the provisions as per which the director will stand disqualified, and as per the question, yeah, over here and over here he is disqualified and over here is not. So that was a very simple and straightforward question. There is not much to explain, right? Then coming forth, you have also been asked in the question in CA Final May 2008. Again in 2008, you were asked the question related to the default in repayment of the matured deposit, right? There was nothing very tricky in the question. All the provisions straightforward given that we have read was asked in the question. Next, in CA Final June 2009, here the question was a little difficult and a little tricky, right? If you go by the reading of the plain text, you may get this answer wrong. You may get this question wrong, but since we are discussing it today, I hope if the similar question appears in your examination, you will get it correct. So in that question, the disqualification had been attracted for the failure to file financial statement for 3 consecutive years, right? But again, there was a failure to pay interest on loan taken from financial institution, and that continued for more than 1 year. Over here, will the disqualification be attracted? The answer is no. The reason is they had failed to pay interest on loan, right? And that was taken from the financial institution. It was not a public deposit on the first case. And as per section 164(2), the disqualification would be attracted only in case of public deposit and not in case of deposit taken from the financial institution. So by reading the plain text from any book, any author that you prefer, you won't understand that the deposit means public deposit. So that is one point to be noted. That is one thing you have learned apart from the book today, right? So in the year CA final May 2010, the similar question was repeated. The similar trick you had, that the deposit was taken from financial institution. And in CA final May 2013 also, you had question on failure to file the annual return and also for failure to pay the interest on matured deposits. So if you look at the provisions of this section, and if you look at the questions, then matured deposit has been a very favorite topic for the institute. You have been asked questions 5 times already in the past years, right? And there has been different tricks in the question. So you'll have to be very keen with these topics now and understand each point in detail. If you have any confusion, you can go back to the previous lecture and understand, right? It's just a 20-23 minutes lecture, right? And everything will be refreshed in your mind again. So now we are done with covering the previous topic, discussing the questions on the topic that we have already covered in the previous lecture. We'll move ahead with the lecture and the topic for the day, right? So today we'll cover section 152 subsection 3 to 153 and 159, right? 153 to 159, all the sections, and that will deal with the director identification number. So the provisions of DIN, director identification number, will be understood at two different parameters. One is when we will discuss about the sections as referred in the topic, section 152 subsection 3 and section 153 to section 159. And when we are considering the sections, we will cover the topic in brief, right? And the second parameter will be when we'll consider the rules for 2014 that pertains to the Companies Act 2013. And when we will be discussing the rules, we will discuss the topic in greater detail, right? So when we talk about the section 152 subsection 3 says that DIN is mandatory for every director. And we have also discussed the same when we were starting the topic, that the only qualification that any director needs to hold is holding a DIN. And DIN is the director identification number, and he needs no other qualification to be a director of a company. And we have also seen that section 164 subsection 1 and subsection 2 deals with the disqualification, and that is negatively stipulated, right? So now we move on to the procedures as per the sections. So section 153 says that an individual has to make an application to receive the DIN, and that application would be made in form DIR3, right? And that application would be sent to the central government along with the fees prescribed and in the manner prescribed in the rules, right? And then once the individual makes an application for DIN to the central government has the responsibility of processing the DIN, and if everything goes correct, he has the right, or he has the obligation to allot the DIN within a period of 1 month as per section 154. And if it does not go correct, if something is missing in the details, or if some detail is found fraudulent, or if there is some other case, right? So what will be the action taken by the CG will be discussed in the rules when we cover the rules for the same, right? So moving on, when we talk about section 156, first we talk about section 155. Section 155 says that a person will hold only one DIN at a time, right? And at a time means for lifetime. But he can have another DIN if there is something major that is changing, and he has to surrender the old DIN and will apply for the new one. But that is a very rare case, because once a DIN is allocated to a person, that is his identification number with which the central government or the MCA site, right, that recognizes the person, and they keep an entire directory of the person referring to that identification number, right? So if one DIN is allotted to any person, he cannot hold another den. Neither can he apply for any other den. Right? So if he wrongfully applies or obtains or possesses another den, he will be punished for the same. Right? And we'll see the punishment for the contraventions further in the coming sections. So as per rule, as per section 155, no person is allowed to apply, obtain or possess another den when he has already been allotted a den. And if in any case a den has been wrongfully received by a person, that is, if a duplicate den has been wrongfully obtained by a person, then that den has to be cancelled or deactivated on immediate basis. Right? Then we have the provisions of section 156, as per which the director has to intimate the den within the period of 1 month to the company. Right? So when a director is appointed to the company, and after the enactment of Companies Act, the director has to hold a den to be eligible to be a director. Right? But the director who were a director of a company before the enactment of this act, they will continue to be the director and will now give an application for den to the central government, right? And they will hold den within the period of next 6 months. So once the director obtains the den, they will have to intimate the den to the company within a period of 1 month, and then it is the duty of the company to intimate the den of all its directors within the period of 15 days of receipt from the director to the registrar or the other authority. Right? So as a procedure, when we go back to the previous section, section 153, the individual gives an application for the den to the central government, and central government allots the den to the applicant within a period of 1 month. And once it has been allocated to the person intimates the same to the to the company within the period of next 1 month. And after the receipt, after the company has received the den from a director, the company has to intimate the same to the registrar of company. So that is the procedure, that is the cycle that flows, right? And if the company fails to intimate the den to the registrar, then the company would attract penalty for itself, right? And that penalty for default would be for the company as well as for the officers in default, and they would combined pay a penalty of rupees 25,000, and that may extend to the maximum of rupees 1 lakh, right? Next is the provision of section 158. So whenever a director is referred to, right, he would mention his director identification number on any document, on any deed, any contract. Whenever a director signs, right, or whichever is connected to that director, the director would declare his den on that document. Wherever he signs, whatever document he furnishes, he will have to mention his den, right? And now in section 159, we talk about the punishment for the contravention of the above sections. But since we are talking about the punishment to the director, so the sections that refer to the other entity, like for example the section referring to CG allotting den within 1 month, section 154, or company intimating to the ROC, section 157, these sections will not be attracted. So the punishment is attracted only for section 152, 155 and 156. Section 152 deals with the appointment of director, and as per the appointment, the director has to have den on a mandatory basis. If it does not have the den and is being appointed, he would attract this penalty of section 159, right? And then the other provision is section 155 and 156. Section 155 deals with the person applying or obtaining or possessing another den. If he does so, he is found to be guilty and would be attracting the punishment under section 159. Next is section 156. That is, if the director, once he obtains the den, he has to inform it to the company within the period of 1 month. If he fails to do so, he will attract the same penalty, right? And what are the penalties? The punishment would be imprisonment up to the period of 6 months. That is the maximum. So the imprisonment would range from 0 period to 1 month, 2 months, 3 months, up to the maximum of 6 months. Or he would also be asked for a monetary fine, monetary penalty, that would be of rupees 50,000 plus rupees 500 per day of default, right? So if it is a default under section 152, a default in appointment, so if he has been appointed without DIN, then he would attract a penalty for 500 rupees per day up to the date till which either he obtains the DIN or he vacates the office, right? And if he holds another DIN, again the penalty of rupees 500 per day would be attracted until he disposes of the other DIN. And if he had to intimate it to the company within a period of 1 month and he does not do so, rupees 500 per day would be attracted till the date he intimates it to the company, right? So that is the meaning of this punishment. So now I presume the various sections of Companies Act 2013 that relates with the procedural part of DIN is clear with you, right? We have discussed it in brief and we'll be covering it in detail when we discuss the rule in the next lecture. So before ending this lecture today, we would revise the various sections. Section 152 subsection 3 says that the DIN is mandatory. Section 153 talks about the point that individual has to make an application to CG, and under 154 CG has to allot DIN within a period of 1 month. As per 155, no person can hold more than 1 DIN. As per 156, the director has to intimate DIN to the company within 1 month. 157, the company has to intimate the DIN. The intimation that is received from the director has to be passed on to the registrar within the period of next 15 days. And as per 158, whenever director has to refer, wherever the director is being referenced in any document or wherever he signs, he has to specify and mention his DIN. And in 159, we have seen the various punishment, right? That is for an imprisonment of maximum 6 months and a monetary penalty of 50,000 or rupees 500 per day of default, right? So with that, we'll wind up the lecture today. And we'll continue with the further provisions in the further lectures. So until then, stay tuned. This is Abhinay Gupta signing off.